Good morning. Welcome to the Hall of Justice for our second day of April case call. We will call the first case of the morning, Batista versus ORS. This is a 15-minute mini oral argument on the application. You may reserve some of your time if we do not use it, and we ask that you keep track of your own time, and you have 2 minutes of a free fire zone, or you may waive that.
Thank you, Justice Clement. May it please the court. Patrick Fitzgerald, Assistant Attorney General on behalf of the Michigan Office of Retirement Services. With me today at council table is Solicitor General Ann Sherman. If I may, I'd like to reserve 2 minutes for rebuttal and will monitor my time. This application concerns the Court of Appeals' untenable holding that superintendents and other public school executives who individually negotiate their pay are not governed by the Retirement Act's normal salary increase limitation. This conclusion represents a fundamental misapprehension of the plain language and unmistakable purpose of the statutory NSI limitation. And it seems unlikely that the Court of Appeals appreciated or even envisioned the effect of its decision. I'd like to focus my remarks on 3 key points in support of our request that this court reverse the Court of Appeals decision. First, the retirement system's longstanding interpretation of the NSI limitation is the only one that gives effect to the plain language of the statute. Section 3A of the statute defines defines compensation, and subsection 2 identifies specific items of remuneration that are to be credited as compensation, and subsection 3 lists items of remuneration that are excluded. Relevant here, subsection 3F excludes compensation in excess of an amount over the level reported for the preceding year, except increases provided by the normal salary schedule for the job classification. In other words, the Retirement Act itself restricts compensation increases to only those that are provided by a normal salary schedule. Importantly, there is no basis for the Court of Appeals reading that this provision only applies to members who collectively negotiate their pay. If the legislature had intended that construction, it could have said so explicitly, but did not. This leads to my next point. The Retirement Act not only authorizes, but it actually requires the retirement system to identify and apply alternative salary schedules for job classifications that have fewer than 3 members. That's exactly what the second sentence of subsection 3F says. This provision should not be understood as applying only to a category of public school employees who collectively negotiate their pay, but who work in job classifications of 1 of 1 or 1 of 2, like athletic directors or public school counselors and the like. If that were the case, the Court of Appeals reading would require the retirement system to disregard salary schedules under which these members are paid, and to then identify and apply alternative schedules. But to what end? You would literally have, for an athletic director who's paid under the salary schedule that lists different schedules for such higher level public school employees.
Whose salary schedule? Who makes their salary schedule? Is it
generally,
ORS?
so when we're talking, what we're talking about here are executives, people who are excluded from collective bargaining. Specifically,
that's not necessarily true, right? Some executives collectively bargain in some districts, like Detroit. It's not. In other words, it's not impossible. It's like in police departments; they have management level unions.
Sure. Traditionally, we're talking about people who individually negotiate their pay. So what the case that's been brought here is on behalf of public school.
I get it, but so
yeah.
I just want to make sure you're talking about, there's collectively bargained schedules, yes. And then there's these ORS schedules. So are you talking about, when you say the athletic director, you're talking about ORS has done a schedule?
So what I'm saying in the case of an athletic director who's paid according to level whatever of the collectively bargained schedule, ORS just they're paid under a salary schedule. We would evaluate their increases, make sure that they're in line with the salary schedule.
So they collectively bargain?
Yeah.
Under your theory?
Right.
Let me ask you this. In terms of salary schedules, if we were to conclude that ORS doesn't have the power under the statute to come up with its own schedules, does anything prevent the local funding units from coming up with schedules outside of the context of collective bargaining?
Nothing would, to my knowledge, most, if not all, superintendents and other executives aren't typically paid according to salary schedules. They're individually negotiated. So under a year-to-year contract, sometimes the contracts cover multiple years, but there isn't a schedule per se.
Because there's not enough employees in those classifications.
For whatever reason, yes. Yeah, so it's individually negotiated.
All right, I interrupted you, I apologize.
No, please.
I guess the next question I have is sort of cut to the chase then.
That was an insincere apology.
He said please, so I think that I invited more questioning. If we were to decide that we disagree with Appellee's position that these limitations only apply to people who collectively bargain, but we also were to conclude that ORS doesn't have the power to make schedules, what happens? What are the closest alternative classifications, or what the
Most
statutes?
nearly identical.
Yeah, sorry, I'm not using the right language, but how would that play out?
Yeah, so if this court were to hold that ORS isn't authorized to develop and apply these alternative salary schedules that they have, the immediate effect would be those salary schedules provided the basis upon which these members' increases were credited. So as it stands, there is no other alternative salary schedule. No one's pointed to any. And I would submit that if ORS were to identify and apply alternatives, say we would be looking at the superintendent for a given district, looking at the most similar job.
Well, it says the most nearly identical job classification in the reporting unit. I suppose it says, or in a similar reporting units.
Right, so practically speaking, I think we would probably look to the salary schedule that would apply to, say, principals. And I would submit that would not be a favorable comparison. Typically, salary schedules do not provide for extraordinary pay increases. By and large, we're talking 2-3% increases. What the Office of Retirement Services has done is develop this methodology that I think fairly and reasonably gives these members credit for increases where in the absence of them, they wouldn't be able to. And this avoids the charade of ORS would be in a position to then identify and apply these salary schedules and would be making some of the same determinations that I think have already been questioned. First, the question of, is this even a similar salary schedule? Two, what information is ORS taking from a salary schedule when they're evaluating superintendent's increase from 200 to 225,000? What does a salary schedule for a principal that shows a level 2 increase from 125 to 128,000? What does that tell us? Are we looking at gross amounts? Are we looking at a derivative percentage? So
under that, I mean, another way to state your argument is that they may be correct in their position that ORS can't create their own schedules, but sort of be careful what you ask for, because you actually may end up worse off, because ORS was trying to do sort of apples to apples in creating this schedule, and what you may be left with is apples to oranges.
exactly,
Okay.
Exactly that.
Council, I'm wondering, what do we do? There is this sort of complicating factor that these are individually negotiated contracts. Districts have to keep up with market rates to get talent. They might have, some new director level people or assistant superintendent level people, and they hire someone, and then there's a pretty big jump for the new person because of, just what the market demands. Does that factor into what the legislature intended at all?
Yeah, I think it does. And in the situation that you described, attracting new talent, that member would be hired at whatever level. They can be paid whatever the school district chooses to provide. What we're concerned about is when somebody is in a position, and then in year 4, there's an extraordinary pay increase.
But doesn't the statute take care of that with saying that if you have sort of, for the purpose of bumping them up, if it's just to bump up for retirement purposes, that's not a legitimate expense or allocation?
So There is indeed a complementary provision that prohibits the intended purpose, the practice of pension spiking. That's where somebody's compensation increases only during their 3 or 5 year final average compensation period. That wouldn't cover, though, someone who's not retirement eligible, say who's in their late 40s, early 50s, who sees an increase from 150 to 200,000, whatever the case. So we're not restricting what school districts choose to pay their employees. We are, though, trying to respect the legislature's clear restriction on the crediting of pay increases. So in that sense, ORS's NSI tables, I think, should be looked at and understood as an allowance. The statute limits it. The statute prohibits the crediting of increases. What we've done, and I think it should be evaluated in that vein, is whether this is an authorized and reasonable method that the board has adopted to provide for the crediting of these increases.
It may be, I mean, I guess, I mean, not disagree with you that it may be an infinitely reasonable thing that ORS has done to do that, but if the statute doesn't currently do that, isn't that something that the legislature has to specify that ORS shall create? Using the method, perhaps, which seems very logical and reasonable, the way that ORS has calculated these schedules for these class of individuals, but doesn't that have to be more of an explicit grant than what's currently in the statute?
I don't think so, and I think with the language that we have already in the statute, it gets us there. The retirement board is expressly authorized to determine what is and what isn't compensation. The statute also not only authorizes but requires the Office of the Retirement System to identify and apply alternative salary schedules. So I think we're looking at not developing a method to further restrict increases, because again, the statute has already done that part of it. What we've done is, through the plain language of the statute, applied this in job classifications with fewer than 3 members, which ORS for 40 years has applied to public school executives in these exact situations, and has developed a methodology that's consistent with the statute to recognize the crediting of those increases.
Are there-
Where in section 1303A3F does ORS have the discretion to develop those schedules, though?
Sure, so recognizing that the statute expressly authorizes the use of alternative salary schedules, and it lists, I think, the key factors: most similar job classification in the reporting unit or in a similar unit. And so here, I think when the board is faced with there aren't alternative salary schedules, and what used to be done back before electronic reporting would be these ad hoc salary studies where we would only, towards the end in contemplation of someone's retirement, we would then begin to evaluate, their increases over the years, and we would identify outliers, and then there would be these ad hoc salary studies conducted. This is what someone was paid in this district or this district. So this has carried over the longstanding interpretation and application of this statute to provide a basis upon which these increases can be credited.
Counsel, I'm wondering, the whole pension system as a whole, I mean, I get it's sort of got this liability, it has to be able to calculate it, it sort of needs guardrails. Do you know, and this is a bit unfair because it's a little off the briefs, but are there other groups that have no limitations on their pension increases? Or as a practical matter, I mean, I know within the state system, usually state employees have set salaries, whether you're part of a collective bargaining agreement or not. We know our clerks have steps, and there's like these set schedules. And so I recognize this is a little odd because these are these groups that are outside, even in the sort of non-collective bargaining unit context. Normally in the state system, you have some kind of a schedule. So I'm just wondering, is that pretty much how it always is?
Yes. And what I'm saying is for the rank and file public school employees, there is never a concern about the normal salary increase limitation. People are paid according to salary schedules.
Right, but I get, so for pension purposes.
Right, for pension purposes, I think this NSI limitation, the statutory NSI limitation, evinces the legislature's intent to avoid a situation where there are abnormal increases. For all those reasons, we're not, when there's a 25% increase in a given year that down the road will impact and have the effect of increasing someone's pension, we're not able to fund that. There aren't mechanisms to recognize for someone, and especially with this population of public school executives. They're the ones who are uniquely situated to negotiate their pay in a way that has these effects.
And what would be, if we were to agree with the plaintiffs, what really is the outcome? Why is this, devastating or harmful? What's the harm?
The harm is that public school executives will now be able to will be able to game the system. They'll be able to structure pay increases in a way that's only favorable to them and will be to the detriment of the retirement system and all of the other members who current and former members. So that's the risk. The Retirement Act right now doesn't have a mechanism that would allow, like we haven't been funding it. We haven't been funding the system. Our funding mechanisms have been set up with this normal salary increase limitation in mind.
Is it, so your position is that they'll get credit for all of their all of these increases without any sort of cap or limitation, or is it the potential that they get nothing?
So yes, that
because there isn't a schedule.
Justice Welch's question is if the plaintiffs have their way. What I would say is if these NSI tables are held to be invalid, then we have nothing. All credited increases and all that would entail, all these manual corrections, we would be starting back at zero.
And you would be comparing the increases, say, to like a principal, or the most nearly identical would be the oranges to their apples.
At best. So I think that would be that is another form of using existing salary schedules. I think that would be a permissible basis. What I'm saying is these NSI percentage tables, I think, are favorable to the superintendents. I think they satisfy the legislative intent.
They're favorable to most superintendents, but not plaintiffs, right?
Actually, I would say to virtually all. If you look at what the NSI allowances are, granted they change from year to year and they reflect what other similarly situated executives are paid in terms of the increase amount that's recognized, but typically we're looking at 2, 3, 4, 5, 6, 7, 8% allowances, which is generally it's more favorable. And so what I'm saying is this. To go back and to do this on a individual basis for these 1,500 or 2,000 public school executives on an annual basis, looking forward, looking perhaps backwards, to identify within the district, here's the principal salary schedule. It provides for $3,000 increases. What is that? Would the retirement system be able to extrapolate and say, well, that's 3,000, but it represents a 2.5% increase, so that's exactly what the concern is right now. That the reading that the Court of Appeals has given to this would totally upset the retirement system's longstanding interpretation and application of this section.
Thank you.
Thank you.
Good morning. Robert Schindler, on behalf of plaintiff appellees, 8 individual currently either retired or still working public school administrators, Patricia Batista, David Britton, Timothy Donahue, Aaron Gaffney, John Hewitt, Ron Kaler, Amy Swantek, Chris Thompson, and the Michigan Association of Superintendents and School and Administrators, who represents hundreds of school administrators throughout the state. With me today is my co-counsel, Adam Walker, as well at council table. The question that this court put before the parties in the supplemental briefing was whether the Office of Retirement Services has the authority under the Michigan Public School Employment Retirement Act to create and implement normal salary increase schedules. And you pointed to 38.1303A3F and 38.1303A5. A unanimous Court of Appeals panel of Judges Fort Hood, Markey, and Gleicher, a panel of long tenured and well-respected jurists, and a published decision answered this question with an unequivocal no. They do not. And plaintiff appellees assert the panel was correct and their decision need not be disturbed. Now, before I go into argument, I'd be happy to waive any time if the panel has any pointed questions before I get into some of the points that I wanted to address.
Can you answer, are there any job classifications in any reporting unit with less than 3 members
Oh, yeah.
that are part of a CBA?
Sure. Yeah, a lot of it.
So that second sentence, to give effect to it,
Yeah.
it applies, there would be a NSI schedule in a CBA for these less than 3 members.
Well,
That would apply to them, or the most nearly identical.
right. So I wouldn't say that there's an NSI schedule. There is a normal salary schedule that applies to them.
Okay.
So as an example, right, you have a transportation unit. Transportation unit may include bus drivers, bus aides, and mechanics in the garage. There may only be 1 mechanic or 2 mechanics in the district. And so those individuals would be part of that whole bargaining unit, but they are part of a classification, which is the language of the statute, a classification of less than 3 members. So they would have a normal salary schedule that's in their contract, and there would be other school districts around in the area that have normal salary schedules with mechanics or the case, or whatever the case may be. So yes, there would be situations where that applies. Now, one point I do want to make, get into this, Judge, is you made this point, and the state refers over and over again to, refers to this section, 3A3F, as the NSI increase section. But that language doesn't actually exist, right? It never says normal salary increase anywhere in that statute. It says increases beyond the normal salary schedule. And it talks about a classification. This is language of bargaining. This is collective bargaining language. The legislature understood that, and the Court of Appeals understood that point. And our position, and the Court of Appeals' correct position on this, is not that, well, if this is gone, what do we do? Because the simple answer to that is this one subsection simply doesn't apply to those people. And that's okay. That happens with all of these subsections. All of them apply to some people, and all of them apply, in some cases, not to people, except for the main point, which is what compensation actually is under the Act, right? So the problem with the state's entire argument is that the exception swallows the rule, right? Compensation, according to the Act, is supposed to be wages, salary, and all remuneration for services provided. That's what subsections 1 and 2 say. Subsection 3 then has exceptions, but the exception can't swallow the rule. So this notion that if we apply this, then there's no limitation on superintendents or assistant superintendents. Of course there is. There just isn't that limitation because they aren't, their salaries aren't negotiated necessarily through normal salary schedules. The point was brought up by Justice Viviano, I believe, that in some cases executives do negotiate, and in some cases there are salary schedules. And that's true. A lot of school districts have principals, coordinators, directors, even assistant superintendents who are either part of bargaining units or who have normal salary schedules. The interesting part is The ORS doesn't apply their normal salary schedules to them if they're assistant superintendent. Instead, they apply their own created ones, which they don't have a right to do.
Let me ask, what textual basis is there for the argument that section 1303A3F refers only to unionized employees who contracted for employment per collective bargaining agreement as opposed to anyone employed in the public school system?
Sure. So I think that's a slightly overly broad, Justice Zara, in that it isn't necessarily just unionized, but it is those who are paid according to normal salary schedules. That tends to be those who are unionized, right? And that language is language of collective bargaining. So textually, looking in here, what it says is increases provided by the normal salary schedule. Now, I don't have to tell this court, but the word "the" is a really important word in a statute. And the state ignores that and over again refers to we need to have a normal salary schedule. The text doesn't say that.
I agree with you on that, and I think Justice Zara is asking an important question, though, that if we're looking at the distinction between "the" and what is missing from this section is any limitation to members of a collective bargaining agreement. So if we're going to be like hyper,
Right.
Looking at words and
Yeah.
and then we kind of have the same problem that this doesn't say anything about excluding non-collective bargaining agreement members.
It doesn't say anything about excluding them, but it doesn't apply to them because they aren't paid according to normal salary schedules. So this exception doesn't apply because the whole point of this is to ensure that the payment being received is actually remuneration for services provided. If you collectively bargain between an employer and their employees, this is what our fair raises are, and our fair wages are for the remuneration for the services we're providing. That's what you get, and you don't get to go outside of that. Now, while a superintendent may not be paid according to a normal salary schedule, they do still go through that same process. They negotiate with their employer, with the Board of Education, what is a fair salary for them. And they should be provided the same. The reality is, the increase that they're applying to superintendents and assistant superintendents don't actually apply to the unionized folks. And that's because if you're a teacher bargaining unit, I can negotiate, and when times are bad, you may not get much. Trust me, I do a lot of collective bargaining for school districts. Over the last several years, there are teacher groups who are getting 6-7% salary increases into their schedule, and then they may take a 4-5% step every year. And they don't bat an eye at that because it's not outside of the negotiated remuneration for their services. So while they may be getting 13% in one year, that's fine, but they determine not the school board who negotiates with the superintendent, they determine you only get 5%, which is about the average NSI raise per year, is 5% for most years. And so it takes away the responsibility from the school board to determine what the proper compensation, what the proper remuneration is for those administrators.
I know how that works, but, so what do we do is it correct that it's essentially operated this way since 1980? Is that an accurate assertion? I know the statute changed in 96, but my understanding is sort of looking at collective salary
Sure.
and creating this average was the norm.
Well, we would say the record does not support that fact. They have said that now. The record supports that the NSI tables were created in the early 2000s. Around 2007, they were created and put into the RIM manual, which is a reporting instruction manual, which is a manual for schools in terms of reporting compensation to ORS. So they were created around 2007. Before then, maybe they did some ad hoc analysis relative to individual members, but individual members should be where they are doing this, not whole scale. And again, our position is that this limitation doesn't even apply at all. And again, this goes back to sort of the notion of you know, the dilemma of the choice that the state puts forward. Either it is chaos and superintendents can get anything or they get nothing, right? It's a false choice, it's a false dichotomy.
What happens, counsel, I'll try to ask my question more, articulate a little better this time, but what happens if we conclude that section 1303A3F applies, but we also conclude the defendants lack the authority to create the schedules? What happens to your clients?
It's an interesting question, Judge Viviano. I think Justice Viviano. I think one of two things would have to happen. Either the legislature would have to step in and do their job in terms of determining how that works. Then,
You're sort of rolling the dice. You're sort of rolling the dice in this case, aren't you, for your clients? If
Yes.
you land there, you end up with less, right?
Sure, yeah, there is always that possibility, and my clients understand that if this is stricken down, ORS may create something new, or the legislature may create something new, and that's part of the risk. But it doesn't mean that the ORS should be allowed to act outside of the legislation with impunity, and that's what they're doing
There
now.
appears to be a gap in the statute, but your clients are among the highest paid public employees in the state, is that right?
I don't believe that that's correct.
Who makes more? I don't know if that's relevant.
Tom
to
Izzo?
Legal analysis. Wow. Is he a public employee?
Yeah, he is. Yeah,
How
you
does
can
his
FOIA his
pension work?
contract, in
How
fact.
does his pension work?
Yeah. So here's the point, and this is an important point as well. You know, this notion,
Can the school
the
district
state
create a
in their-
schedule?
the
Let me
state
just
in
ask
their-
before you go on.
Yeah.
Can the school district create a schedule applicable to superintendents and administrators?
Sure,
Okay.
yes.
Does that solve the problem that's presented by Justice Viviano?
Yes and no. I mean, I think if all school districts had that, and they all had those schedules, then ORS could look at similar schedules of similar school districts to look at what is comparable.
Isn't that what they did?
No, what they did is they took salary from one year and then salary in another year and looked only at the increase, not the salary itself. And that's an important point because the statute says a normal salary schedule, right? So if I'm a principal and I get a job as a superintendent and I've never been a central office administrator before, and they say, Bob, we think you're great. We want to bring you in, but you've never done this job before. The average superintendent in our area makes about $150. We're only going to pay you $120. But if you do great, we'll ramp you up. Okay? I come in, I do great. They ramp me up. I make $130 the next year. I don't get credit for that whole $130 because the NSI is only 5%. I get to go to about $126. And then that compounds year over year, and what happens is now I, as a school administrator, who are selfless people generally, have to act with self-interest, and I have to say, well, if I leave this district and I go somewhere else, then I get uncapped and I can make whatever I want according to the ORS. So now I have to leave a district where I'm doing great and they love me for my own personal self-interest to help my pension, instead of allowing that school district to actually negotiate what's fair and what's right in the pension system, respecting it. And then the school district pays into the pension system for that amount.
But of course, you know, as Brother Counsel noted, of course, they can leave for the higher salary, but of course, the issue is just how much will be credit, the increase goes towards the pension.
But if they leave for the other salary, all of it's credited, Justice. So if they go, if I'm making $150 and the district next door will pay me $200,000, I can leave and I can do that, and that next year, according to ORS, my basis is $200,000. It doesn't matter if I'm in the first year as a superintendent or my very last year before I retire, okay? And this notion that it's uncapped is also not true because we have other limitations. Sorry, if I may finish my one sentence real quick.
No, you can keep, I have another question after that, so
Section
keep going.
3A, 3E prevents spiking, which is the danger here, right? Which is driving it up right before you retire to affect your pension, because that affects your actuarial tables, because now you're not putting the money into the system that is needed. But if it happens mid-career, it isn't going to have that same impact because they're putting in a percentage of your salary every year into the system. So 3A, 3E actually prevents the danger they're talking about, and that's why it's there. It doesn't, we don't need 3A, 3F for those individuals because we have the school boards to be able to negotiate and put the money in, and 3A, 3E is there to protect against the dangers.
Okay, so my last question is we have a pension system that obviously has been under scrutiny a lot the last 20 years in schools. Like the viability of the whole system has been questioned. It's been one of the top concerns that superintendents have had to manage is the pension liability and that the cost that got passed along to the local districts. How do we square that with that you have this system that was designed, I think, per this clear language, to have some guardrails to ensure that the costs could be managed with your argument?
Yeah, so a few points. One, the pension system right now is in the best position it's been in since the early 80s. Okay.
Right, because a lot of work happened to make that happen.
And most of that work is being done by the school districts because the school districts are putting in more and more money every year. So yes, you're right. It is a major concern. Trust me, again, I do a lot of collective bargaining. When I'm there, we have to talk about here's what the salaries are, but here's what that means with pensions because we're paying 30% of that payroll into the pension system, and that's gone up and up and up over the years to create that viability. There's been other legislative changes as well. But the main point on that is, again, if my salary goes from 150 to $200,000 because I've knocked it out of the park and ranges are going up and I started low and so on and so forth, the district's now going to pay 30% on my $200,000 salary. And that's going to go into the system to help fund my pension and fund the system. And one last point, and this goes back to Justice Viviano's point about highest paid folks and a point that the state makes in their brief where they talk about this notion that superintendents, they say, quote, are typically receive salaries in excess of $200,000 and topping out at over $400,000 annually. Now, interestingly, they cite to the Mackinac Center on that, which is interesting because they're the pension system and have all the salaries. But nonetheless, I went to that Mackinac Center website and looked at it. And the reality is, it just isn't true. There are less than 50 superintendents in the state who make over $200,000. Of the 540 some on the Mackinac Center's website, over 300 of them make less than 150. So we aren't talking about, fat cats sitting here counting their chips. We're talking about public educators who have dedicated their lives to public education and deserve the pension that they worked for and they negotiated and they worked hard to negotiate with their employers. So if there's no other questions, thank you very much. I appreciate your time.
Thank you. Thank you both. The case will be submitted.